Iku Iluna, please rise. Ia ka aha ho o kolo kolo ki e ki hano hano ua a koa koa ho maila. This Honorable Supreme Court is now reconvened. Inoho Ilalo, please be seated.
Please call the case.
Case number SCWC-23-0000185, State of Hawaii, Respondent Plaintiff Appellant versus Randall Hoffman, Petitioner Defendant Appellee. Arguing for the Petitioner Defendant Appellee, Randall Hoffman, Benjamin Lowenthal. Arguing for the Respondent Plaintiff Appellant, State of Hawaii, David Seaver. Argument on the merits.
All right. Good morning. Aloha. Today's proceeding is being broadcast live on the Judiciary's YouTube channel as well as on Olelo. Counsel, are you both ready to proceed? All right. We have an hour for our argument today, 30 minutes for each side. We'll let you know with 5 minutes to go in your argument, Mr. Lowenthal, so you can reserve that time for rebuttal. We'll let you know with 5 minutes to go as well, Mr. Seaver. Please proceed. Thank you.
Mr. Chief Justice, and may it please the court. The ICA's categorical exception to the Pa'ahana test is unworkable, unconstitutional, and unprecedented. It is unworkable because courts now have to determine what is attendant to arrest in custody. Categorical exceptions are supposed to guide the lower courts, the parties, and the police with bright-line rules. They should be easy to understand and simple to follow. This categorical exception doesn't do that. It needlessly complicates voluntariness hearings. It does nothing to help the courts reach the truly important question of whether the officer influenced the suspect into talking. And it falls apart. Ketchum and Skapinock insist that actions done pursuant to a legitimate police procedure can still be interrogation under Pa'ahana. So now trial courts have to draw this line between a legitimate police procedure from something that's attendant to arrest in custody, which is categorically excluded. And Ketchum already settled that routine booking questions, for example, are a legitimate police procedure subject to Pa'ahana, and yet a booking question is also attendant to arrest in custody. The exception effectively overrules Ketchum and creates confusion. The exception is also unconstitutional. The ICA ruled that a statute requiring an officer to inform Mr. Hoffman the grounds for the arrest prompted him to respond and therefore is not interrogation. But that means that an officer is required to do or say things pursuant to a statute or say an administrative procedure like a booking question. Court's hands are tied and there's no interrogation. This is wrong. Our courts determine if there's been an interrogation and constitutional violation, not the legislature, not the police. And finally, the exception is unprecedented. This court has never adopted an exception for words or actions that are attendant to arrest in custody. Now, granted, it has been declared an important consideration in Trink. It has been called a carve-out from the definition in Skapinock, but this court has never altered the Pa'ahana test itself. And whenever this court had an opportunity to create an exception, it's rejected them. It should stay this way. This case is an excellent vehicle for the court to clarify any confusion, uphold the supremacy of the Pa'ahana test, no exceptions. It must remain the law of the land because it fulfills Miranda's promise that a defendant's confession can only be used against them when they voluntarily give it, not because they were coerced.
Counsel,
Yes.
We did say in Skapinock that, even though we called it a carve-out, we indicated that Hawaii law points against eliminating the incriminating response inquiry, even when the police ask questions attended to a routine legitimate procedure. So I wanted to, that's your understanding of Skapinock, right? Skapinock does not create a blanket carve-out for routine legitimate procedures. It says that the constitutional incriminating response inquiry is still governing.
That's right. And Skapinock does have this language about a carve-out, but ultimately the holding is just that. They go back to Ketchum's rejection of the routine booking questions and said, we didn't do it then. We're not going to do it for medical rule-out questions. So the Pa'ahana test is the one that applies.
Thank you.
My question is, this case deals with a situation where there's ongoing activity which is the subject of the potential offense. Different, isn't it, from where, like the OVUII cases where the individual has been stopped already, a traffic investigation is ongoing, different when an individual has been taken into custody and is asked, how's your Halloween going, things like that. I think that's the interesting factor here. What is a law enforcement officer to do in a situation where they come right upon the scene, see somebody committing an offense? What is an officer to do?
I think what an officer is to do is essentially do what this officer did. And the officer approached, saw something that was, in the officer's view, a criminal act of littering, engaged in conduct. And it's very important from our perspective that we are dealing with the question of interrogation. And we all know that it's a two-part inquiry. The question of custody has been resolved, was not taken up by the state here.
Right,
So-
conceded. Custody is conceded.
Correct. And so in a lot of ways, it parallels the problem in Scapanock, because that was exactly the same situation. Custody was not the issue in Scapanock. The question was whether these medical rule-out questions was a form of interrogation. And so what an officer is to do is to approach the situation, and they have their training and experience. If they see an ongoing offense and they have made the decision to detain, the question of custody is there. It would be litigated. Now, assuming there is custody, then the question is, what are the words or conduct like? Were the words or conduct likely to elicit, and I'll just say response, incriminating or not? And if the answer is yes, then it is not voluntary under our Constitution.
So in this instance, the DLNR officer approached Mr. Hoffman, told him these were DLNR lands in which he was throwing green waste, and told him to stop because it was illegal. And then there was the first response, right, from Mr. Hoffman.
So the ICA breaks them up. And it's interesting to point this out, is that the ICA breaks them up, but the trial judge who heard the testimony, saw the live testimony, made presumably these credibility decisions, didn't see it that way. In their conclusions of law, they said it was the invitation to begin this dialogue. And so it's our position that while the ICA did break them up and said 2 out of, say, I think 3 are voluntary, that's not, on the record, that's not exactly what the trial court did.
I'm looking at the trial court's findings of fact, 11 and 12.
Okay. And their conclusion, I believe it's number 12, is how the conclusion of the trial court is by pointing to the sign, number 13, conclusion of law number 13, by pointing to the sign, saying you're on state land, that was the beginning of this dialogue. And so from our perspective, we believe that the trial court correctly made the assessment based on a totality of the circumstances that this was an ongoing back and forth.
So there are specific responses from Mr. Hoffman that
Correct.
are in issue. But my question to you, though, is just given that initial approach by the officer and the officers pointing out that there's illegal conduct, please stop, or you should stop, and there's a response, how is that, if we were going to apply the Scapanic test and move away from the arrest proceedings and so forth, why is that comment by the officer reasonably likely to elicit an incriminating response?
I think based on the totality of the circumstances, again, we have the issue of custody is resolved. So assuming Mr. Hoffman is in custody upon this approach, we then look to the officer's words or conduct. You have an officer in a uniform in a remote area on the west side of Kauai, in a marked vehicle approaching Mr. Hoffman, telling him to stop. And by his own testimony, I believe, he said he was not free to leave at this point. He was still deciding whether to give even a citation or a warning. But the main point is Mr. Hoffman wasn't permitted to leave. So I guess my
He wasn't
answer,
told that yet at this point, but that's what the officer testified.
Correct.
Right, okay.
in that situation, in a remote area, no one else being around, a uniformed officer saying, you're on state land, stop what you're doing. The trial judge made the decision, based on those circumstances, said that that is the kind of conduct under the Pa'ahana test likely to elicit a response. The issue is whether that can be short-circuited with a categorical exception pursuant to a statutory obligation. And so we believe that on this record, the trial judge correctly applied the Pa'ahana test. To answer your question, Justice Canosa, as to what an officer is to do, they can Mirandize pretty quickly. And if
So
they,
that should be the first words out of the officer's mouth is, you have the right to remain silent and all of that?
well,
Without any initial,
if the officer is going to engage in what the trial court described as a dialogue or as an invitation to a dialogue, we believe yes.
But wasn't the officer, I'm sorry.
No, go ahead.
Wasn't the officer trying to de-escalate the situation? They're out in the middle of nowhere. There's three people. He's approaching them. He doesn't want to arrest him. He just wants him to stop. And so he tries to point out to the defendant, stop, there's a sign, please stop. You know, how is it further the purposes of Miranda to, first of all, require the officer to Mirandize somebody? And how does that, you know, doesn't that escalate rather than de-escalate the situation?
I think there are techniques, and I don't want to speak for officers in any way, but it's as simple as say the conduct could occur, and before any answer happens, to say, you know, I got to give you some warnings before we go any further, or dispense with the warnings. And frankly, this is not a motion to dismiss. The issue before us is whether we are dealing with.
That's right. You know, Mr.
Yeah.
Lowenthal, you know, I mean, police officers, I mean, what does a police officer do? The police officer could do exactly what the police officer did, right? It's just that whatever your client said is just not introduced in the trial.
That's correct. And I would, in this situation, you can have the officer testify about what he saw, what he did, what Mr. Hoffman did. We're talking a very discrete, narrow piece of evidence, which is the defendant's statements.
And let me talk about, you know, there's talk about 8036. And 8036 is sort of this, you know, you're being arrested for X. And, you know, in the real world, you know, do detainees think after that comment, you're being arrested for burglary or murder or anything of that nature, that they might feel the obligation to explain themselves or think that their silence suggests guilt or maybe try to talk themselves out of an arrest? There's been a lot of talk, at least in the brief from the prosecution, the 8036 is we have to let them know what they're arrested for. And that sort of sparked some of this chain of comments. But as far as 8036, how does that really operate in the field, in your experience?
In my experience, telling an arrestee what they're being arrested for should be subject to Pa'ahana. And I'll point two things out. There's a textual problem with 8036. Specifically, it says that the person who's arresting without a warrant should give the party arrested clearly to understand for what cause, et cetera. We're dealing with a should. So what the prosecution describes as a statutory obligation, it's not as clear in the statute. Now, moving away from the text into the real world, we should interpret statutes in accordance with constitutional norms, and that you can comply with the statute and Miranda. I'm going to tell you what you're being arrested for, but I'm also going to tell you about your constitutional rights. And that would solve any problems. You can comply with the statute and the Constitution. Happens all the time.
And sorry, one more question. On the 8036, when you're saying they should do this, I mean, that's sort of an encouragement. What if they don't? Does it matter?
Right. We'd be in a very different place if a defense argued that they should have told me what I was being arrested for, and therefore, what's my remedy? But I mean, that's a different case entirely. It's unclear.
So it seems that 8036 is just, well, kind of big deal. I mean, it's something that maybe we should do, maybe we shouldn't do. And why should that even invite comments by a defendant to get us to arguing before the Supreme Court?
I think it also goes towards the unworkability of this categorical exception. You have a statute that is a little unclear. And if that is going to become the basis to say Pa'ahana doesn't apply if there's simply compliance with the statute, then you have the role of the legislature deciding what police words or conduct is exempt from the Miranda requirement, essentially. It also creates practical problems on the trial level, right? Because now the issue is no longer whether there was likelihood of a response. The issue is whether the statute applies. And it just takes us further and further away from the whole point of Miranda.
You know, in the briefing before the ICA, I think the position that was asserted on behalf of your client was that neither Miranda or the Hawaii Constitution prevents an officer from ordering a suspect to cease illegal activity or illegal behavior. Isn't that really what happened in this case? The officer comes up as an on-view violation, and he's explaining to the person why he's there and why he's having this contact, and telling him there's a sign there, what you're doing is illegal. You know, pick it up. And I understand he didn't have an intent to arrest or cite. He was going to actually give the guy a break and let him go. And that's when things went from there. But why was that initial interaction where, if you go off your brief, and I hope I'm reading it correctly, that Miranda or the Constitution doesn't prevent from at least that introduction in telling them why I'm here and what it is that I'm making contact with you about?
I believe it doesn't prevent officers from doing their job, because Miranda ultimately is a rule of evidence. And as in my answer to Justice Edens, is that the officer has, an officer in the field has to make many decisions very quickly. And in this case, it is our position that the officer, assuming that there's custody, once the person is detained or not free to leave, the officer has to make a decision. Before I engage in this conduct, do I apprise Miranda if there's time? If it's an emergency or something that in which the officer has to act quickly, they act quickly. And if it's conduct likely to elicit an incriminating response, then when we get to a voluntariness hearing, all that's going to be excluded are the words of the defendant, not the officer's actions. And so in the briefing, and our position today is, this isn't stopping officers from doing their job, preventing emergencies and keeping people safe. It's really about a discrete rule of evidence on the defendant's statements.
Right. And, you know, if the officer doesn't say anything, just approach, I mean, that can cause a lot of problems too, right? You understand the other side of it. You got to explain why you're there and what it is that why you're engaging with the potential suspect. I mean, are we saying that that's not allowed anymore?
No, and I apologize, we're not saying that. Well,
to simply inform somebody you're littering, there's a sign right there, this is public land, it's DNR lands, and that's why it's a violation. Please stop, pick up your rubbish, and you can leave. Is that a problem?
Well, that's different than simply approaching. Simply approaching, you have all kinds of issues as to whether that's even custodial. And so you have the first issue, which
assuming detention, because that's
Sure.
what the officer conceded to.
So assuming that it is custodial, this person is not free to leave, and the officer approaches, and with no words, and we just look at the conduct of, as the officers like to say, officer presence, right? That would be I could see that in that scenario, that would be a much, much harder case for the defense when applying the Pa'ahana test. Now, whether there are exclusions to that test or not, and I should just demonstrate that, in that factual scenario, this shows why we should keep Pa'ahana as is, because it is flexible enough to look at that scenario as opposed to what we believe is this case where the officer does more.
What if the situation was the officer comes up to Mr. Hoffman and says, you know what, I'm placing you under arrest for criminal littering. There's a sign right here, this is public lands. That's why I'm placing you under arrest. Then he makes statements from there. Would you say that that should be, that was prohibited?
Well,
or that would have been prohibited?
Prohibited is a difficult response for me, because
sure. What I'm trying to set is that it's in the course of an arrest now. You have attendant circumstances. I'm trying to effect an arrest. and now I'm telling him why I'm arresting him, subject to 803-6.
Sure.
And now he starts making statements.
I believe in that scenario, if an officer were to make the active arrest and start to engage in it and say, you are under arrest for these reasons, say pursuant to the statute, I think compliance with Miranda at that point also requires warning them that anything they say could be used against them.
Before you explain why you're arresting them, or after?
I believe it is a stronger case to give the warning after stating the grounds for the arrest. Frankly, it's no different than how most lay people understand Miranda, that they think as soon as they get arrested, the officer's got to read them their rights.
And that's actually what happens in most jurisdictions, right? It's kind of like Hawaii has certain jurisdictions that are kind of like the exception to the general rule that other departments follow, which is you're under arrest for murder. You have the right to remain silent. They just go right into the Miranda rights, but for some reason, we don't do it. Some of our jurisdictions don't do it.
That's right. And that practice is seen every single day on television and in movies. And if you talk to people who aren't attorneys, that's what they assume they have. And I can't speak from experience that there are many times where people say, but he never read me my rights. And that is correct. Most jurisdictions, and we would submit the better practice is simply read the rights upon arrest.
But there's reasons for that, because sometimes the police department wants the detectives to do the rights and do the questioning. They don't want it done in the field. So there's reasons for that.
Understood. And I believe...
Especially when it's a felony.
Correct. And there's nothing stopping the detective from doing the same thing. Rights can be read multiple times throughout the course of a criminal investigation.
But what I'm saying is that's why sometimes it's not done in the field right away.
And
Because they don't want to cut off their questioning in the field.
Our position is that when a person's in custody, whether they're in the field or later in the police station, and that there's conduct that would be subject to pa'ahana, those statements say they're in the field, can't come in. Now, say a detective comes in later, does the full briefing, reads the rights, goes through the forms, and there's a confession. Well, clearly, the confession would be admissible. However, this prior statements don't. And that does lead to an interesting question. When the prosecution makes the decision, getting away from the police practice, and the prosecution makes the decision that not only do I want the confession from the detective, but I want whatever was said in the field, that's what leads to this issue, and that's what leads to these problems. So it's our position, anyway, that there's nothing stopping the field officer from simply reading the rights upon taking the person into custody.
And I don't think I disagree with that. Can I switch real quickly
Sure.
and just ask you, the part of this whole progression where you get to Mr. Hoffman seemed to have been going after the officer. There was a physical scuffle or fight that was going on. And now the officer is fighting back, trying to gain control of the suspect. And he's saying, stop resisting. Why would that be inappropriate? Because at that point, he's giving a command. He's trying to de-escalate the situation. He's trying to gain control over the arrestee. And I think Mr. Hoffman responds somewhere along the line, okay, I'm done. Why is that inappropriate? And why should that be excluded when it's simply trying to stop an illegal action that was being perpetrated on the officer?
Well, the officer also, I believe, punched Mr. Hoffman twice in the face, and that's when he said, okay, I'm done. And the question really comes down to the ICA's analysis. According to the ICA, that apparently telling him stop resisting, 2 strikes to the face is pursuant to this statute. And that's all they say. They don't apply pa'ahana. They just said pursuant to a statute. It's not interrogation. And we would take a position that we have to look at those words or conduct and apply the totality of the circumstances to see if it was likely to elicit an incriminating response.
Wait, you keep talking about totality of circumstances. Didn't we clarify in Kazanis that is not the test for interrogation? That's only the test for custody? And it's the only test for interrogation is whether it's the acts or conduct are reasonably likely to lead to an incriminating response. So we're not looking at totality of circumstances as to whether or not the conduct or actions or statements are reasonably likely under a totality of circumstances.
I see where I misstepped. I guess I agree that the substantive standard is looking at the officer's words or conduct, et cetera. How do we do it? I would suggest when we talk about words or conduct, and I don't want to use the
Well,
phrase.
that's a factual, mixed
Correct.
question of fact,
Right.
fact and law.
And-
And in this case, the circuit court determined that under these facts and the testimony, she found it to be interrogation, reasonably likely to lead to an
That is
incriminating
correct.
response.
And
Now, in terms of the subsequent statements, and aren't we kind of dealing with like a Trinquet type situation? I mean, here, the officer said there was probable cause upon the time he approached, and the defendant was not free to leave. That, under Ketchum, as reaffirmed by Hewitt, is classic. There's probable cause, you've got to give the Miranda rights, right? You don't have to give them. If you don't give them, because you didn't give them Miranda rights, the defendant's statements just aren't admissible. But the police officer is not required to immediately say you're under arrest. It's just if you have probable cause for arrest and you don't arrest and you don't give Miranda rights, if your statements or conduct were reasonably likely to lead to an incriminating response, then the defendant's statements just don't come in. And under Trinquet, it's kind of like fruit of the poisonous tree. You know, you can't just say, if our officers gave the rights, we wouldn't have all of these cases where we're trying to parse out at what point, or what about this, what about that, what about this, what about that, right? Upon arrest, clearly he was under arrest subsequently when they were fighting. He was already under arrest, but he still hadn't been given the rights, right?
yes, that is correct. That is our position, Your Honor.
Are you taking the position that the officer trying to gain control with someone that's attacking him or her, who's saying stop resisting, that's a statement reasonably likely to elicit an incriminating response? Is that your position?
That is our position, and that was the position of the trial judge when applying Pa'ahana. And in looking at all of the facts and circumstances, you know, it is also our position that the trial judge looked at it as a whole and did not parse it out like the way it was done in Trink.
No, I understand your point on that, but this statement, stop resisting, the officer says it several times. You're taking a position that is an inappropriate statement by the officer.
It is a statement likely to elicit the incriminating response. And I don't want to say it is inappropriate necessarily because we're looking at the officer's conduct here. It's simply a person in custody and then engaging in something that the trial judge found and we agree with that prompted the response, okay, I'm done. Stop resisting, 2 strikes to the face. Was that likely to elicit some kind of response from Mr. Hoffman? He says, I'm done. And so it is our position that at that point, and it should be said that like it escalated. Now it'd be different if that was the only interaction. That'd be a little harder. But if we looked at the whole statement from beginning to end, as the way the trial judge did, it's part and parcel interrogation.
You know, there's been all this talk about Miranda rights. In 2022, there was a case, maybe you're familiar with it, maybe not, Vega versus Tico. And in Vega versus Tico, the court, the United States Supreme Court said that, you know, if you're interrogated without knowledge of your Miranda rights, then you got no remedy under 42 U.S.C. 1983. So what you said, you know, about TV, everybody knows about the American tradition of Miranda and all that. It's not actually a constitutional right. It's not in the text of the Fifth Amendment. It's not part of our history and tradition. There's no remedy for a right that doesn't exist. And the United States Supreme Court has now said in that case that it's a prophylactic rule, not a right. Miranda has possibly been silenced, not yet, but with the Supreme Court precedent does seem advisory. There was a case called Dickerson in 2000 that they reaffirmed the Miranda rights. What will it mean if the United States Supreme Court follows through in the criminal context what it did in the civil context by saying that that is not a right?
My light's on, but I want to answer this question. I will say, thankfully, we have 51 state constitutions to look to, and I know that this court has a robust practice and tradition of looking at our state constitution for independent grounds. And so if the United States Supreme Court would have to, in my view, go through some logistical gymnastics to get around what, and I should say, while we're on the subject, Chief Justice Rehnquist wrote Dickerson. And this was a person who spent his career hating Miranda. And by the time he comes around in 2000 to talk about that this is in fact a constitutional protection in which Congress cannot legislate out of existence, is a sign of hope. So,
Well, Scalia wrote Chevron, or endorsed it rather.
that's
Anyways,
beyond my pay grade.
Sorry,
So,
sorry, Mr. Lowenthal, I digress. Sorry, Chief Justice.
No.
I see my light is on. I wish to reserve the rest of my time.
All right, thank you,
Thank
Mr.
you.
Lowenthal. We'll hear from Mr. Sieber now.
Good morning, and may it please the court. Once again, my name is David Sieber. I'm a deputy prosecutor for the County of Kauai. And we're asking the court to find that the defendant's statement, the majority of the defendant's statements to Officer Tavares were admissible as a matter of law. And this court,
Be sure to keep your voice up. Sometimes
I'm
it's-
sorry.
It's just trailing off a bit.
I was warned about that, Chief Justice, by your bailiff. This court could take this case as an opportunity to issue a very broad ruling encompassing all kinds of contact that an officer has with someone who's in custody. Or this court could choose to be more pinpoint and address the very specific set of circumstances presented here, where an officer is issuing commands to an individual simply to get him to stop actively committing a crime in the officer's presence and to submit to the officer's authority. When the court set this case for argument, it indicated the single question presented was whether or not an officer's words and conduct, quote unquote, normally attendant to arrest and custody, could arise to an interrogation, triggering the need for Miranda warnings. This court's use of the verb arise is a little bit open-ended. If the court meant that a contact that began,
You're talking about the statement on our website. That's simply meant as something to indicate to members of the public whether they might be interested in coming or not attending the argument. So it's not a preliminary ruling of the court in any way.
understood, Your Honor. Thank you for clarifying that for me. I think the reason that that issue is central to this case is because of Rhode Island versus Innis, where that language about words being normally attendant to arrest and custody as opposed to express questioning or statements likely to elicit incriminating responses is sort of a carve out from the rule requiring the provision of Miranda warnings. And of course, an initial contact between an officer and someone he has in custody that begins with words and conduct normally attendant to arrest and custody can develop into something more the functional equivalent of an interrogation. We saw that in Trinket.
Isn't the whole problem for you that, to argue attendant statements, attendant circumstances relating to an arrest, that the officer said, hey, I did detain Mr. Hoffman at the point of contact. I had a on-view violation, but he had no intention of arresting. So how do you get to the argument that the statements made by the officer were relative to the affecting an arrest?
Right, and to the extent the state wishes to sort of back away from the suggestion that this contact was normally, that the officer's commands to this individual were normally attendant to arrest and custody, this court can certainly do so. This court's never...
I'm sorry, what did you say, that last part?
This court can certainly decide that the officer's commands do not fall within that category of words that are quote unquote normally attendant to arrest and custody. I do think that...
So you're conceding that the ICA erred?
I'm asking, this court can affirm on any number of grounds that are supported by the record.
But in terms of that, you're now the state is now conceding that the ICA erred.
I'm saying that the court can certainly do this. I think the court could conclude that this officer was attempting to effect an arrest ultimately, and that these kinds of words, when an officer is telling someone to submit to them, those could be considered normally attendant to arrest and custody.
The officer was pretty candid in saying that he was trying to give the guy a break. He just wanted him to stop, pick up his rubbish, and leave the area. That's all he seemed to be trying to achieve. He was not any intent to arrest or cite. Is that a correct reading of the record?
It is, Your Honor. And the reason I mention this is because this is, an incident of criminal littering. The danger to the community was relatively minimal, but this situation arises all the time when officers come onto a scene and they're witnessing ongoing criminal activity taking place in front of them.
Well, part of it is you have to look at what the statements are as the circumstances unfold, I mean, initially, certainly he had no intent. The officer said, he testified, I had no intent to arrest him, I just wanted to cite him. And I actually just wanted him to stop,
Exactly.
give
That-
him a warning, right? But as things unfolded, the circumstances changed.
as Mr. Hoffman made clear to the officer, he had no intention of stopping committing the crime in his presence and ignoring the officer's commands, not just ignoring them, but responding with a string of
Right, we have
expletives.
not talked about the specific responses, but they were quite pointed responses from Mr. Hoffman.
And clearly indicating to the officer that this person had no intention of stopping his criminal activity. You know, this court hasn't really taken the opportunity to define what the term words and conduct normally attendant to arrest and custody are. In Skaponic, the court said that those kinds of questions, the medical rule act questions, are not. It makes all the sense in the world. Those were questions designed to further an investigation. They were not the kinds of booking questions or the kinds of words that the legislature suggested an officer has to say under HRS 8036.
But here, counsel, where the officer makes the initial statement and he informs Mr. Hoffman that his conduct is illegal, points to the sign that's right there, why wouldn't he give the Miranda warning at that point?
And again, Your Honor, this is a situation where if this court wants to limit its decision to cases like this, where the officer is not intending to arrest somebody, where the officer is just trying to give somebody a verbal warning, essentially, if the court wants to decide that Miranda warning should be given in that situation where there's no ongoing danger, obviously this situation escalated. The officer's words initially did not have the effect they wanted on Mr. Hoffman. But this court's decision in a case like this will affect a broad spectrum of contexts where officers arrive on scene while a crime is occurring in their presence. So there was really nothing normal about this interaction between Mr. Hoffman and the officer. To the extent that this does not fall within the category of words and conduct normally attendant to custody or arrest, then the statements that Mr. Hoffman made would still be admissible because they were not the kinds of words and conduct, once we set aside the carve-out that the NS court set for the specific kinds of contexts. These were not the kinds of words, these commands the officer made, not questions, just commands, that would be reasonably likely to elicit incriminating information.
So are you, in terms of, you know, the FU phrases, are you arguing that those are not incriminating?
It doesn't, the way incriminating is, I think, do they further an investigation or prosecution? This court and other courts have held that incriminating responses don't necessarily need to be inculpatory. They could be exculpatory. They're just discussing or relevant to what is transpiring in front of the officer and could be of relevant use at trial. So whether they were kind of, he was digging his own grave effectively.
So it's not the actual response, it's whether there's
Exactly.
reasonably likely to lead to
Exactly.
an incriminating response.
Yes, Your Honor. Is this interaction the functional equivalent of an interrogation with all of the inherent sort of intimidating, and there's a risk of coercion in a police-dominated atmosphere where an individual who's in custody is being subjected to interrogation.
As a practical matter, there's nothing in this case that prohibits the officer from testifying as to what he saw, littering,
Correct.
and what the defendant did.
There certainly isn't.
And we're here on an appeal on this pretrial voluntariness statement because you're trying to get in these statements.
Because we believe the circuit court erred when it found that what the officer was doing when he was issuing commands to this individual to stop committing a crime in his presence amounted to the functional equivalent of an interrogation.
When Mr. Hoffman was fighting with the officer, do you argue that's a functional equivalent of an interrogation when the officer is now saying, stop resisting?
No, Your Honor.
Trying to de-escalate, and it's an officer safety issue. It's a safety of the suspect himself and the public.
Absolutely, Your Honor. If I misspoke and suggested that I believe what occurred, that the
No, I was
state
just
believes
asking
what
you.
occurred.
You did not.
Of course.
I was just asking the question.
No, and the test is what the suspect, would a reasonable officer believe that the suspect would hear these commands, stop resisting, stop littering, as would that person feel like they were being interrogated? Are those words reasonably likely to elicit an incriminating response? And if the officer believes that that's what's going to happen, or should believe that's what's going to happen, he's not to ask those questions without providing
And in terms of
remand
that,
orders.
the only response at issue there is the "I'm done" statement, right?
And also the string of expletives.
I'm sorry?
Oh, in terms of the stop resisting?
Yeah. The
that-
only statement of the defendant that you're contesting along those lines is the "I'm done" statement, right?
I'm also arguing to the court that the defendant's statements in response to the officer's commands to stop littering before the officer has to go hands-on.
Okay, no, but I was just asking about
Gotcha.
the physical interaction.
And I think, again, the officer's repeated commands to Mr. Hoffman aren't the functional equivalent of direct questioning of Mr. Hoffman because they weren't, again, reasonably likely to elicit testimonial evidence from the defendant. This goes back to the whole reason why we have the Fifth Amendment and Miranda warnings in the first place. They're designed to avoid putting a person in that term, that cruel trilemma of feeling compelled to either incriminate themselves.
I'm sorry.
Oh, I'm sorry.
I don't understand what
apologize.
you're saying.
The Miranda warnings and the Fifth Amendment are meant to protect individuals in this country from being put in what they call that cruel trilemma of feeling compelled to either incriminate
Have we
themselves.
used that language under our Constitution?
It's just it's not, if the court wants to consider this under an Article 1, Section 10, it certainly can. I
I thought this was an Article 1, Section 10, or Section 10 issue.
Fifth Amendment and Article 1, Section 10 is my understanding.
Okay, all right.
Again, but the issue was just because there's such an inherently pressure-packed situation when an individual is being questioned by police investigators for the purpose of gathering evidence in a custodial setting, the person might feel compelled to incriminate themselves even though they have the right not to. So to protect against that, which the Miranda court and this court have generally held is
Does
kind
the
of a
person
social
have
rule.
the thought that maybe they're going to incriminate themselves when in 803.6 you are being arrested for X is given? I mean, doesn't that question alone or that information alone possibly generate an incriminating response?
I think you are being placed under arrest for the crime of X. It serves a separate need to inform the defendant, the arrestee, why he's being arrested, then it is likely to, it certainly doesn't serve the purpose of eliciting an incriminating response. The legislature required it. They weren't telling the police how to do their job. They were saying, this is what you have to do to legally effectuate an arrest. Will some individuals respond by saying, I didn't do it, or yeah, you got me? Perhaps. But is it reasonably likely to produce that response? There will be people like Mr. Hoffman who respond in a way that the officer wasn't anticipating or predicting. Your Honor is sort of suggesting that it's effectively goading someone into making a statement. But the purpose of providing that information to a defendant is because the legislature required it. It's the same as kind of those booking questions when somebody like in, I want to say in the Ikaika case.
Wait, I'm getting very confused
I'm sorry.
now. I thought when he initially approached, there was no arrest being effectuated. The statute only requires it upon arrest, right? Or says that you should explain upon arrest, right? So how does the statute even apply here?
Again, Your Honor, this case has ramifications beyond this particular incident. I understood your colleague's question to be asking, is that statute effectively unconstitutional in all situations? Because it's reasonably likely to elicit an incriminating response. This case is an atypical situation because I suspect the kind of minor nature of the offense and the officer's desire to just give a verbal warning. As I understood your question, if an officer places someone under arrest and they read them this question, is that a statement, words or conduct reasonably likely to elicit an incriminating response? I would say no.
And you did that does accurately fit the question, but I mean maybe it's circumstance dependent, because let's say a police officer comes onto the scene, of a fellow holding a knife. He's all bloody. His roommate's lying down next to him. The officer says, put the knife down. He puts the knife down. And then the officer looks at things and says, okay, put your hands behind your back, cuffs him. I'm arresting you for, well, murder. And then the person says, whoa, wait. I just picked up the knife. I was, helping you guys out evidence-wise. I wasn't here, and, I'm not going to lie to you. My roommate stole my drugs, but I wouldn't kill him, or says whatever. I mean, aren't there some situations where that 8036, you should tell him this, is going to invite problems?
So it's a great question, Your Honor. Courts that have analyzed this sometimes will look less at what effect will these words have on a particular individual in a particular instance, and more, what was the purpose of the officer asking that question? For instance, in the booking process, officers will ask questions, in most cases would not be reasonably likely to elicit an incriminating response. They just have to do it for administrative purposes. In a situation like 8036, the officer is doing it not to gather information, not to conduct the functional equivalent of an interrogation, but because the legislature said you have to do this when you're effecting an arrest. So the issue presented to this court is, does the court want to apply the traditional Innis test of saying words or conduct reasonably likely to elicit an incriminating response necessitate Miranda warnings, other than, under the Innis test, words or conduct normally attendant to arrest and custody? In every instance, officers are supposed to abide by 8036 and tell every arrestee, here's why you're being arrested. Under the Innis test, and there's no way to read this as including words normally attendant to arrest and custody, those kinds of words or conduct expressed to an arrestee are not subject to the requirement that Miranda rights be provided, because the purpose of those is not to gather information. The purpose of them is to comply with the statute. So that would be a situation where under the Innis test, an officer could do this without providing Miranda rights.
Counsel?
Yeah.
Did I hear you saying that we should be considering what the officer's subjective intent is in terms of these lines of questioning, or what statements made?
If I did say that, I didn't mean it that, I did not mean that. What I meant was, are these questions asked of every arrestee pursuant to some administrative or legislative purpose separate from interrogation? And there's simply no way to read that carve-out in the Innis test to effectively not be there. There would be no point of inquiring, are these words or conduct attendant to arrest and custody normally, if the answer to that question was immaterial and you still looked to whether it was reasonably likely to elicit an incriminating response. So under 8036, to answer that question, this would fall within that Innis exemption.
Well, let's come back to the original initial encounter between the officer and the defendant. Your analysis of that is that it's the comment, stop doing this, was not reasonably likely to lead to an incriminating response?
Exactly. I don't think an individual in Mr. Hoffman's position, a reasonable person in Mr. Hoffman's position is not hearing stop littering as an invitation to express his opinions, to deny what he's doing right in the officer's presence. It's to comply with the officer's commands. The officer is telling me this not to get me to make admissions. He's not subjecting me to interrogation. He just wants me to stop my actions. Same as if an officer orders somebody out of a stolen vehicle. An officer tells someone to drop the knife, tells him to take his hands off of his ex-girlfriend's neck. The officer is trying.
Could you please
I'm sorry.
speak up? I'm really having a hard time hearing.
I apologize.
Thank you.
The officer who's encountering a crime being committed in his presence and is commanding the person committing the crime in his presence to stop doing that should not be expected to believe that this person he's talking to is going to interpret that as anything other than a command to stop doing the actions. It's not the functional equivalent of questioning. If the person complies with the officer's commands, that's what the officer wanted.
How does this situation square up against the sort of classic, you talked about the trilemma, that the goal of Miranda was to not put people in that situation. How does this situation stack up against more classic Miranda situations? What's different about it, or what's the same?
I think the test is always, particularly when we're not talking about express questioning, but we're talking about commands or words or conduct. So not direct inquiries of an arrestee as to the crime he's under detention for. I think the question always has to turn to how would a suspect in that situation reasonably interpret the commands, the words, or conduct of an officer. In Trink, this court concluded that Mr. Trink experienced the officer's or the lieutenant's conversation with him as essentially, oh, this is somebody I can talk to. I can let my guard down and talk to him. Because the officer was trying to build rapport with this person in a way that he clearly was conducting a narcotics investigation and wanted information from this person. I mean, that was clear from the statements the lieutenant was making to Mr. Trink. This is different. This is an officer who pulls up on a scene and sees a crime being committed in his presence. He's not asking the suspect any questions. He's simply trying to get the suspect to stop. The suspect is refusing to stop, and the officer continues to command him to stop. And the person he's encountered is indicating to him he has no intention of stopping.
Can I go back to 8036? You know, many times the situation is it's the suspect asking the officer, what am I being arrested for? So in a situation like that, is the officer required to give Miranda rights first before answering?
It's probably in an abundance of caution that's the way to proceed, because now the individual has expressed his intent to provide information that could inculpate or exculpate him. So now it's developing into an interrogation. This is one of those situations where...
Well, it's the suspect just asking, what am I being arrested for? The suspect has no idea. They want to know.
If the only response the officer makes is a response that's compliant with 8036, you are being arrested for X. The purpose of that is to comply with the legislative edict. It's a statement that's provided to every arrestee, or at least it's supposed to be.
I understand, but should Miranda be given first before responding, consistent with 8036?
It's probably best practices to tell this person of their Miranda rights. But the answer to the question, assuming that the officer has not already told him what he's being placed under arrest for, the officer's answer to that question complies with 8036. If the suspect asks first before the officer can tell him, the officer can certainly answer that question because he's obligated to anyway. But depending on what the suspect says, if it's just, what are you arresting me for? And you say, bank robbery. That's in compliance with 8036. That should not be a Miranda issue. If the person says, wait, I want to explain, now it's clearly developing into something more akin to an interrogation that would occur back at the station before the officer says, bank robbery. Would it probably be advisable? Yes. To Mirandize him, of course. Is it constitutionally necessary? I think it's really fact-specific on each case, and it really depends on what the suspect says first.
Yeah, Counsel, didn't you folks cite like an Oregon case and New York case? I mean, do those cases help here? I mean,
you know, when you get ready to present to this court, you review all of your documentation, you review all your submissions, and the ICA affirmed this case on the grounds that these were terms that were normally attendant to arrest and custody. I'm not entirely sure the ICA that was the only basis on which these statements could be admissible. This court could readily find that these kinds of statements are not normally attendant to arrest and custody, but still find they were not the product of commands that were reasonably likely to elicit an incriminating response.
right, your Schmidtke citation, I mean, that's the circumstances there, I think.
Yeah,
Okay.
exactly, Your Honor. Ultimately, again, this court could find that Officer Tavares' commands to Mr. Hoffman to stop his ongoing criminal conduct were normally attendant to arrest and custody, because when officers come on scene and they see a crime being committed in their presence, they normally command a person to stop. But it's not necessary to do that here, because this was an unusual situation, although it's one that sometimes arises. And the arrest and custody exception may not apply here. But if this court does decide that the ICA was wrong in concluding that this fell within that Innis carve-out, this court can still deem Mr. Hoffman's responses admissible because they were not the product of a custodial interrogation that occurred in the absence of Miranda warnings. This was an officer telling someone to stop, and the person who was being ordered to stop decided that he wasn't going to, despite the officer's commands. And his responses in that regard were not the result of the
In terms
functional
of
equivalent
the
interrogation.
officer saying stop, that was only at the time of the physical fight, right?
No, he began by telling him to stop littering and explained where the defendant was and how littering is a crime.
That was his first statement? I didn't understand that to be his first statement.
I'm sorry.
I thought his first statement was, hey, you're violating, littering is, you can't litter here. This is illegal. Look at that sign.
Right. He was commanding him to stop littering. And then he told him again when Mr. Hoffman told him, F you. And he said, stop littering. I'm telling you to stop littering. F you. And then it ends up escalating into a situation where the officer's now struggling with this person in this remote location. None of those statements that the officer made, again, not express questioning certainly, but none of those statements are the functional equivalent, again, of an interrogation happening back at the police station. That's not their purpose, and that's not how they were received. If the court doesn't have any further questions, I'll just yield the remainder of my time. Thank you.
All right, thank you, Mr. Sieber. We'll hear rebuttal from Mr. Lowenthal.
I wish to focus on what the ICA's analysis actually has done, and that is they do not apply the Pa'ahana test. They do not apply the inquiry as to whether the officer's words or conduct were likely to elicit a response. What they do instead for two statements is they refer to a statute for the first statement, and then in the second one, there is no reference to the statute. They simply say this is attendant to arrest and custody. What I wish to point out on rebuttal is this court has gone down a very similar road for booking questions, and the answer is booking questions are subject to Pa'ahana. Questions pursuant to a statute should be no different because Pa'ahana is flexible enough to encompass all of the facts that surround the encounter. Once we start making these shortcuts by looking to only an exception, we get further and further away from the whole point of Miranda, which is to look at the officer's words or conduct to see if it was a coercive environment or the functional equivalent.
How was this a coercive environment? And the defendant didn't know that he was subject to arrest. They're kind of standing out there in the middle of a field and the officer's asking him to stop.
He's out there in a remote area with, although it's in the record, with a child, with a woman in the truck, and the officer encounters him and begins telling him that he can't be doing this. And I guess I'll say it this way, is that we start off with Miranda saying it's to prevent what the functional equivalent, but we've distilled it down to this test, and that is that Pa'ahana test. Now, sometimes in the application of the test, is it consistent with the overall purpose? Maybe not every time, but it is the test that is to ensure that the defendant's statements are not to be used if it is, in fact, in response to something likely to elicit a response.
Can't officers do general on-the-scene questioning when they first arrive at a crime scene? And where does that end up? If isn't that still a part of what can take place?
That's a really excellent point, because if you actually look at Pa'ahana, they do talk about that. And I'll just submit that while the Pa'ahana test, as it's formulated, has continued, what has gone through some changes is where we make the line for custody. And so once you have the two things, the general on-the-scene questioning does come into play it does come into question if, in fact, the suspect is in custody. I think in the traffic situations, you have a lot of situations where there's reasonable suspicion, but maybe not custody. That requires the probable cause. So I think the general on-scene questioning at this juncture is really a closer focus as to whether the person's in custody or not.
In other words, the on-scene questioning is kind of like to try to figure out what's going on. But once you have probable cause,
Right.
let me ask you this. You're really here arguing that the ICA applied the wrong test.
Correct.
Right? And you're saying that under the correct test, which you're saying that the circuit court applied, the circuit court properly found that these statements were not, concluded that these statements were not voluntary.
That is correct.
You're saying that it is whether or not, are you saying that whether or not it's reasonably likely to lead to an incriminating response is a case-by-case determination of factual, depending on the circumstances of each case?
That is correct.
So what if the circuit court here had found the other way, that under these circumstances, was not likely to lead to the discovery of incriminating response? Would you be arguing that the circuit court erred?
No, because we would not be making that argument. We are simply asking to.
So you would, if the circuit court had said that applying the correct, in your view, if the circuit court had applied the correct test, but found that the officer's statements or conduct were not reasonably likely to lead to an incriminating response, you would not be raising that issue
Right.
on appeal after a conviction or something.
I think the issue would actually be would not be as much of a legal issue. Well, it's still a legal issue, but the issue in that situation is whether the application of a test we can all agree upon was done correctly.
Right. Okay.
What we have here, and I see I have the red light, is that we have a test that's been put in place and been used by trial courts all over the state for the last 40 years, and it should remain that way without any exception. And so what the ICA has done by elevating the exception over the actual test is the legal error that we ask to correct and reinstate the suppression order.
Mr. Lowenthal, coming back to Justice Edens's hypothetical person standing with the bloody knife, body on the ground, your position would be there's arguably probable cause to believe the person with the knife has committed a crime. So at that point, the obligation is to Mirandize the person as opposed to simply asking what's going on here?
Well, I'm glad you mentioned that because I believe Justice Edens's example is a really good example of why we should just keep the Pa'ahana test. In some context, if it's just compliance with the statute, that's just compliance with the statute. But if we let that elevate over looking at whether the act of complying with a statute in a way that is somehow likely to elicit a response, that's what the real inquiry here. We don't want a situation where officers engage in coercive conduct and then turn around and say, well, I was just complying with the statute. It doesn't allow courts the flexibility. Well, Pa'ahana allows courts the flexibility to look beyond simply statutory compliance to see, well, we can see you're complying with the statute, but maybe the way you complied was in a way that was likely to elicit an incriminating response, and therefore, notwithstanding the statutory obligation, Constitution requires that it be inadmissible.
Did you argue the Fifth Amendment here, or did you just argue Article 1, Section 10?
I believe, given the precedent, and I don't want to misspeak, we are saying that the state constitution is primary. And I say that mainly because of Ketchum's rejection of book and question exceptions.
Well, anything further at this point, Mr. Lowenthal?
No, thank you.
All right. Thank you to both of our counsel for your arguments today. The court will take this matter under advice.
E ku iluna, please rise. Ua ho'oku'u ia mai nei, ke aha ho'okolo ki ike hano o ka moku aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.